Before we begin, a quick and important disclaimer. The following content is provided strictly for educational and entertainment purposes. It does not constitute legal, financial, or tax advice. Divorce laws and economic impacts vary significantly by state and individual circumstance. We are not licensed attorneys or certified financial planners. Viewers are strongly encouraged to conduct their own due diligence and consult with qualified professionals regarding their specific situation before making any decisions related to matrimonial or financial matters. Every 60 seconds in the United States, another legal contract is severed, initiating a massive shift of capital that most people never see coming until the ink is dry. While we often discuss the emotional toll of a marriage ending, there is a hidden, cold-blooded machine running underneath the surface. A $100 billion industry that fundamentally reshapes the American middle class every single year. Most people believe they understand the cost of a divorce. They think about the attorney fees or perhaps the division of a savings account. But they are missing the forest for the trees. We are looking at a systemic economic event that can effectively erase 20 years of wealth building in a matter of months. What if I told you that the true economic footprint of a divorce isn't found in the courtroom, but in the decades of lost compounding interest, the structural collapse of credit scores, and the permanent shift in tax liability that follows a household split? Today, we are opening the books on the massive financial reality of the modern American breakup, starting with the specific mechanics of how wealth is liquidated in the current market. By the end of this deep dive masterclass series, you will understand the precise financial architecture of a separation in the United States. We are solving the problem of financial blindness. Too many individuals enter this process focusing on the immediate battle, while completely ignoring the long-term war for their financial survival. We are going to look at historical trends and case studies that demonstrate how a single legal decision can alter your net worth by 6 figures over the next 10 years. You will learn how to identify the hidden leakages in a settlement, from the often overlooked capital gains tax implications on a primary residence to the nuanced valuation of future pension benefits. This is about moving from a position of emotional vulnerability to a position of informed economic strategy. To understand the economic footprint of divorce, we must first look at the sheer scale of the disruption to the domestic unit. In the United States, the household is the primary engine of economic stability. When that engine is split in two, the efficiency isn't just halved. It is often reduced by 60 or 70% due to the loss of economies of scale. Think about the basic physics of a household budget. A single roof, a single heating bill, and a shared high-speed internet connection provide a foundation where two people can live for significantly less than the cost of two separate individuals. When a divorce occurs, these fixed costs do not vanish, they double. 2 mortgages or 2 rent payments immediately enter the equation. This is the first and most immediate shock to the economic system of the individuals involved. Let's examine a case study of a standard suburban household with a combined income of $150,000. While married, this couple may have a high discretionary income, allowing for aggressive contributions to retirement accounts and college savings for children. Upon filing for divorce, the legal system begins a process of equitable distribution or community property division, depending on the state. However, the legal fees are just the tip of the iceberg. Historical trends suggest that the average contested divorce in the United States can cost between $15,000 and $30,000 per person in direct legal expenses alone. If the case goes to trial, those numbers can easily triple. This is capital that is being extracted directly from the family's net worth and moved into the legal services sector, providing zero long-term ROI for the family unit. Beyond the direct costs, we have to talk about the liquidation of assets in a volatile market. When a court orders the sale of a family home to facilitate the division of equity, the timing is rarely optimal. The couple is forced to sell regardless of whether the real estate market is at a peak or a trough. This forced liquidation often results in a lower sale price than a strategic, patient sale would have yielded. Furthermore, the transactional costs of selling a home, realtor commissions, closing costs, and moving expenses can eat up 10% of the home's total value before a single dollar is divided between the parties. For a house worth $500,000, $50,000 effectively vanishes into the ether of the transaction. This is a massive hit to the collective equity of the separating couple. Then there is the issue of the divorce penalty in the tax code. For years, a couple may have benefited from the married filing jointly status, which offers wider tax brackets and higher standard deductions. Transitioning to single, or head of household, status often results in a higher effective tax rate for the same amount of individual income. This means that even if a person maintains their exact same salary post-divorce, their take-home pay is reduced because the government is taking a larger slice of the pie. When you combine higher taxes with the increased cost of maintaining a separate household, the standard of living for both parties frequently drops. Data suggests that for men, the standard of living may dip significantly in the short term, but for women, the economic footprint is often even more severe, with historical trends showing a potential 30% drop in lifestyle sustainability in the years following a split. We also have to account for the disruption of career trajectories. Divorce is a high-stress life event that requires an immense amount of life admin. The time spent in mediation, meeting with accountants, and dealing with the logistics of moving is time taken away from professional development. Case studies have shown that individuals going through a high-conflict divorce often see a temporary stagnation in their earning potential, as they miss out on promotions or are unable to take on the extra projects that lead to career advancement. The opportunity cost of a divorce is perhaps its most insidious economic footprint. It is the promotion you didn't get because you were in a deposition. It is the business you didn't start because your capital was tied up in a frozen joint account. As we move forward in this masterclass, we are going to break down the specific sectors where this money flows. We are going to look at the insurance industry, the credit markets, and the long-term impact on the American social safety net. We are entering an era where the gray divorce among those over age 50, is on the rise, creating a unique set of economic challenges for retirement security. When you split a retirement nest egg at age 60, there is no time left for the market to heal the wound. The compounding interest that was supposed to fund a 30-year retirement is suddenly cut in half, leaving two people to face the rising costs of healthcare and housing with significantly fewer resources. This isn't just a personal tragedy. It is a macroeconomic shift that affects the entire country's financial health. We are going to look at how this impacts everything from the housing market to the way banks assess risk for personal loans. The economic footprint of a divorce is a permanent mark on the ledger of the American dream, and understanding it is the first step toward mitigating the damage. To grasp the full weight of this permanent mark, we must dissect the immediate structural collapse of the joint credit profile. In the American economy of 2026, your credit score is your financial heartbeat. It dictates your ability to pivot, to refinance, and to survive the transition from one household to two. Imagine a scenario involving a couple, Mark and Sarah, who have spent 15 years meticulously building a combined credit history. They own a home in Virginia with a manageable mortgage and 2 auto loans. Their credit scores are both in the high 700s because they have utilized the synergy of a dual-income household to ensure every payment is made on time. However, the moment the legal process of separation begins, this synergy is replaced by a high-stakes vulnerability. Most joint accounts, including credit cards and lines of credit, become a liability field. If Mark decides to stop paying the joint credit card to preserve cash for his individual legal retainer, Sarah's credit score is dragged down simultaneously. There is no middle ground in joint liability. This isn't just about a few points on a FICO score. It is about the potential outcomes for their future borrowing power. Historical trends indicate that a drop of 100 points in a credit score during a divorce can result in tens of thousands of dollars in extra interest payments over the next decade for something as simple as a new car loan or a rental application. The destruction of the credit profile is often a secondary effect of the liquidity crisis that hits in the first 90 days. When a household splits, the immediate demand for liquid cash skyrockets. You have the security deposit for a new apartment, the cost of furnishing a second living space, and the aforementioned legal retainers, which in 2026 often start at $5,000 per person for even basic representation. For a couple like Mark and Sarah, who might have their wealth tied up in home equity and 401k plans, this sudden need for cash creates a desperate situation. They may be forced to tap into retirement accounts prematurely. Under current tax laws, taking an early distribution from a traditional IRA or 401k before age 59 and a half triggers an immediate 10% penalty from the IRS, on top of the funds being taxed as ordinary income. Imagine withdrawing $50,000 to cover divorce costs. Between the penalty and a combined federal and state tax rate that could hit 30%, Mark or Sarah might only see $30,000 of that original $50,000. They have effectively vaporized $20,000 of their future stability just to fund the present conflict. This is a step-by-step erosion of wealth that is rarely factored into the initial decision to separate. Furthermore, we must look at the hidden mechanics of the shared economy of scale. In a married state, the cost per person for essentials like car insurance, health insurance, and even cellular plans is significantly lower due to multi-line discounts and family coverage rates. When the divorce decree is finalized, these individuals move into the single-payer category. Historical trends suggest that an individual's car insurance premium can jump by 20 to 30% simply because they are no longer part of a multi-car policy. Health insurance is an even more volatile variable. If Sarah was covered under Mark's employer-sponsored plan, she now faces the prospect of COBRA coverage, which can cost upwards of $800 to $1,200 a month, or navigating the open market where premiums for a single adult in 2026 have continued to outpace wage growth. This is a recurring monthly drain that fundamentally alters the monthly cash flow. If you add up the increase in insurance, the loss of shared utility costs, and the higher individual tax burden, a person earning $80,000 a year might find that their effective purchasing power has decreased by nearly 40%, even though their salary hasn't changed by a single cent. We also need to address the psychological impact on financial decision-making, which acts as a force multiplier for economic loss. Behavioral economics teaches us that under extreme stress, humans tend to favor short-term relief over long-term gain. This is known as hyperbolic discounting. In the heat of a divorce, one party might say, "I just want the house, you take the retirement accounts." On the surface, this might look like an even split if the equity in the house is $400,000 and the 401k balance is $400,000. But this is a mathematical trap. The house is a liability-heavy asset that requires maintenance, property taxes, and insurance, and its value is locked behind a liquidation cost. The 401k is a tax-advantaged growth engine. 10 years down the line, the person who took the 401k will likely have a significantly higher net worth due to compounding interest, while the person who kept the house might be struggling with a roof replacement or rising property tax assessments in a gentrifying neighborhood. Case studies of American divorces show that this failure to account for asset quality versus asset quantity is a primary driver of post-divorce poverty, particularly for the custodial parent. Step by step, the economic footprint expands from the individual to the community. When a high-net-worth couple divorces, they often pull their investments out of local businesses or sell off shares in family-owned enterprises to settle the books. This can lead to a localized contraction of capital. If Mark and Sarah owned a small franchise together, the need to buy out one partner's share might force the business to take on high-interest debt or reduce its staff. The divorce doesn't just affect the two people in the courtroom. It ripples through their employees, their suppliers, and their local tax base. In 2026, with the rise of the creator economy and independent consulting, many couples are effectively business partners. Dividing a digital asset, like a YouTube channel or a software-as-a-service platform, presents unprecedented valuation challenges. How do you split the future earnings of a personality-driven brand? How do you account for the loss of a key editor or strategist who happen to be the spouse? These are the new frontiers of the economic footprint that the legal system is still struggling to quantify. As we go deeper into this deep dive, we have to recognize that the financial recovery period is getting longer. In the 1990s, a person might recover their pre-divorce net worth in 5 to 7 years. In the current economic climate of 2026, characterized by high housing costs and specialized labor markets, that recovery period has stretched to nearly a decade. This is 10 years of lost opportunity, 10 years where you aren't investing in the next big tech cycle, or saving for your children's higher education, because you are still paying off the debt incurred during the litigation phase. Every dollar spent on a lawyer is a dollar that isn't working for you in the S&P 500. This is the ultimate cost of the process, the death of the alternate timeline where your money stayed in the market and grew. But what happens when the assets aren't just cash and houses? What happens when the dispute moves into the realm of the intangible, like professional degrees, future royalties, or even the valuation of a stay-at-home parent's contribution over 20 years? The calculation becomes exponentially more complex, and the potential outcomes become more unpredictable. We are moving toward a section of this masterclass where the numbers stop being abstract and start becoming deeply personal. In the next part, we are going to look at the specific trap of the family home. It is the largest asset for most Americans, yet in a divorce, it often becomes a financial anchor that drags both parties down. We will examine the math of the mortgage buyout in an era of fluctuating interest rates and why the person who wins the house might actually be the one who loses the most. If you think the legal fees are expensive, wait until you see what happens when the bank gets involved in your settlement. The family home is often the crown jewel of the American dream, but in the context of a 2026 divorce, it frequently transforms into a financial anchor. To understand the gravity of this, imagine a homeowner named David. In 2021, David and his spouse secured a mortgage on a $600,000 home in a suburban tech hub at a historical trend low interest rate of 3%. By 2026, the home value has appreciated to $800,000, leaving $200,000 in equity. In a standard equitable distribution scenario, both parties expect their $100,000 share. However, the mechanics of extracting that value are fraught with systemic friction. If David wants to keep the house to provide stability for his children, he must buy out his spouse's $100,000 interest. In the lending environment of 2026, he cannot simply keep the existing 3% mortgage and take out a separate loan for the equity. Most lenders require a full refinance of the primary mortgage to remove a spouse's name from the deed and the debt. This is where the math turns predatory. Refinancing that $600,000 balance at 2026 market rates, which might hover around 6 or 7%, nearly doubles David's monthly interest obligation. He isn't just paying his spouse $100,000. He is signing up for an additional $2,000 a month in interest payments over the next 30 years. Over the life of that new loan, David will pay hundreds of thousands of dollars more than he would have in the original marital household. This is a potential outcome that many people overlook in the heat of negotiation. They focus on the deed, but they ignore the debt service. Historical trends show that the spouse who keeps the home often ends up house poor, possessing a high net worth on paper, but having zero liquidity to manage daily expenses, leading to a higher risk of foreclosure within 5 years of the divorce decree. Now, consider the alternative, the forced sale. If neither David nor his spouse can afford the buyout or the new individual mortgage payments, the court may order the house to be sold. This triggers a cascade of transactional leakages. First, there is the 6% realtor commission, which on an $800,000 home is $48,000. Then come the closing costs, repair credits for the buyer, and the logistical cost of 2 separate moves. By the time the dust settles, that $200,000 in equity has shrunk to perhaps $130,000. When split, each party receives $65,000. In the 2026 rental market, that $65,000 might cover only 2 years of rent for a comparable property. They have traded a permanent, appreciating asset with a fixed low cost for a rapidly decreasing pile of cash and a lifetime of exposure to rising rents. The economic footprint of the family home also extends into the realm of capital gains taxation. Under current United States tax law, a married couple filing jointly can exclude up to $500,000 of gain from the sale of a primary residence. A single individual can only exclude $250,000. If the house has appreciated significantly since the purchase, the act of divorcing and then selling as a single person could move the individual into a massive tax liability. Imagine if the home was bought for $200,000 and is now worth $800,000. As a married couple, they pay zero tax on the $600,000 gain. As a divorced individual, David might owe capital gains tax on $350,000 of that profit. This is a silent extraction of wealth by the IRS that occurs simply because the timing of the sale shifted from the marital period to the post-divorce period. Beyond the brick and mortar, we must analyze the step-by-step collapse of the shared emergency fund. In a dual-income household, the risk of a job loss or a medical emergency is mitigated by the second income. It is a form of internal insurance. Upon divorce, that insurance vanishes. In 2026, the average American requires a much larger cash reserve to feel secure in an era of gig work and high-cost living. Case studies show that post-divorce individuals often resort to high-interest credit card debt to cover basic life emergencies that would have been a minor blip in a marital budget. This reliance on revolving credit creates a debt spiral. If David's car breaks down and he no longer has a spouse's savings to lean on, he puts the $4,000 repair on a card with a 24% interest rate. Because his monthly cash flow is already strangled by the new mortgage or high rent, he only pays the minimum. Within 3 years, that car repair has cost him $8,000. This leads to the invisible cost of logistical redundancy. Every household needs a lawnmower, a set of tools, a vacuum cleaner, and basic furniture. When one household becomes 2, these items must be duplicated. This consumerist tax is often ignored. If you have to spend $15,000 just to make a second apartment livable, that is $15,000 pulled away from your retirement accounts. In a masterclass on economic footprints, we must account for these microtransactions because they aggregate into a massive macro loss. We are looking at a total recalibration of the individual's net worth trajectory. The person who was on track to retire at 62 now looks at the spreadsheet and realizes 68 or 70 is the new reality. We must also look at the impact on life insurance and estate planning. In a marriage, life insurance is a tool for survivor protection. In a divorce, it becomes a line item in a settlement, often used to secure alimony or child support payments. The cost of maintaining these policies, or the cost of new policies for a person who is now 5 or 10 years older than when they first insured themselves, adds another layer of monthly expense. Furthermore, the legal fees to rewrite a will, update power of attorney documents, and change beneficiary designations across a dozen different financial platforms represent hundreds of hours of professional labor. In 2026, administrative complexity is at an all-time high, and the friction of disentangling two lives is a massive drag on productivity. As we move through the data, a clear picture emerges. Divorce in America is not a one-time event. It is a permanent structural shift in your financial DNA. It changes the way you interact with every financial institution, from your local bank to the federal government. But there is a factor that is even more volatile than real estate or tax brackets, and that is the disruption of the human capital of the next generation. The economic footprint of a divorce doesn't just stop at the parents. It cascades down to the children, affecting their future earning potential and their own financial stability. In the next part, we are going to dive into the massive industry of child support and alimony. We will look at the algorithmic ways the state determines how much of your paycheck belongs to someone else, and the historical trends of how these payments affect the long-term wealth of both the payer and the payee. We will explore the hidden incentives within the system that often keep conflict high and bank accounts low. If you think the division of assets was complicated, wait until you see how the government calculates the value of your future time. We are going to expose the math that the court uses to decide your financial future for the next 18 years and beyond. The calculation of future time begins with the cold, mathematical reality of child support and spousal maintenance, often referred to as alimony. In the United States 2026, the state does not view your income as a personal reward for your labor, but as a shared resource that must be reallocated to maintain a semblance of the marital standard of living across two separate households. To understand how this functions, consider a character named Robert, a mid-level software manager earning $140,000 annually. When Robert and his spouse decide to part ways, the court applies a standardized formula, often based on the income shares model, used in a majority of states. This model operates on the theory that a child should receive the same proportion of parental income that they would have received if the parents had remained together. The math starts by combining the gross incomes of both parents to find a basic support obligation from a state-mandated table. If Robert's spouse has been out of the workforce for 5 years or earns significantly less, Robert's share of that obligation could easily reach 20 to 25% of his take-home pay. Imagine if Robert's monthly net income after taxes is $8,000. A court order requiring $2,000 a month in child support immediately reduces his individual purchasing power to $6,000. Over the course of 18 years, or until the child graduates high school, this represents a total capital transfer of $432,000. This is not a tax-deductible expense for Robert under current federal law, meaning he is paying that amount with post-tax dollars, effectively requiring him to earn nearly $600,000 in gross wages just to satisfy that single line item of the divorce decree. This transfer of wealth is a fundamental component of the economic footprint, because it creates a long-term cash flow constraint that limits Robert's ability to invest in his own future. While the recipient spouse may use those funds to maintain the children's lifestyle, the pair often finds themselves unable to qualify for new loans or mortgages because lenders include child support and alimony as a recurring debt in the debt-to-income ratio. If Robert wants to buy a modest condo to be near his children, the bank looks at his $6,000 of remaining income and subtracts his other debts. That $2,000 support payment has the same impact on his mortgage eligibility as a massive luxury car payment, potentially locking him out of the real estate market for a decade or more. Alimony, or spousal maintenance, adds another layer of complexity and financial drain. Historical trends show that while lifetime alimony is becoming rarer, rehabilitative alimony is a standard tool used to bridge the gap for a lower-earning spouse. Imagine if Robert's spouse needs 3 years to finish a degree or re-enter a specialized field. The court might order an additional $1,500 a month in maintenance. For those 3 years, Robert is living on $4,500 a month while earning a six-figure salary. This creates a psychological and economic phenomenon known as the middle-class squeeze. Robert is technically wealthy by national standards, but his liquid reality is one of extreme frugality. This is a potential outcome for any high earner in a long-term marriage where there is a significant income disparity. The step-by-step impact of these payments often leads to a secondary economic effect: the erosion of work incentives. When a significant portion of every overtime hour or every bonus is automatically diverted to a former spouse through wage garnishment or updated court orders, the motivation to climb the corporate ladder can diminish. Case studies have shown that some payors reach a point of diminishing returns where the stress of a high-performance job is no longer justified by the small percentage of the increase they actually get to keep. This results in a stagnation of human capital development, which is a hidden cost to the broader American economy. We must also analyze the enforcement mechanisms that back these financial transfers. In 2026, state agencies have unprecedented access to digital financial records. Failure to meet these obligations can lead to the suspension of professional licenses, the seizure of tax refunds, and the freezing of passport privileges. The administrative footprint of maintaining compliance, tracking payments, filing for modifications when income changes, and paying for legal representation to navigate these adjustments is a constant drain on time and mental energy. If Robert loses his job or takes a pay cut, the support order does not automatically adjust. He must file a formal motion with the court, a process that can take months and cost thousands in legal fees, all while the original debt continues to accrue as arrears with high interest rates. Furthermore, let's look at the impact on the payee. While child support is intended to benefit the children, the economic reality for the receiving spouse is often one of precariousness. Relying on a monthly check from a former partner is a form of counterparty risk. If Robert's company downsizes or if he faces a health crisis, the income stream for the other household can evaporate overnight. This forces the receiving spouse into a position of high financial sensitivity, where they may be unable to make long-term financial commitments because their primary income source is outside of their direct control. Historical trends suggest that custodial parents, despite receiving support, often have lower long-term wealth accumulation because they are frequently the ones sacrificing career flexibility to manage the day-to-day needs of the children. The economic footprint of support payments also intersects with the rising cost of higher education in the United States. While most state child support orders end at age 18, many parents in 2026 find themselves negotiating for college tuition as part of a comprehensive settlement. Imagine if Robert is also required to contribute 50% of a state university's tuition and board. With costs for public universities trending toward $35,000 a year, Robert is looking at an additional $70,000 over 4 years. When you aggregate the child support, the alimony, and the educational contributions, the total economic transfer from a high-earning parent to the other household and the educational system can exceed $1 million over a 20-year period. This reallocation of capital fundamentally changes the wealth-building trajectory of both individuals. They are no longer operating as a single unit maximizing a combined portfolio. They are two separate entities, often working at cross-purposes, with a significant portion of their wealth being consumed by the friction of the legal and administrative systems. This isn't just about moving money from pocket A to pocket B. It is about the systemic loss of efficiency. Every dollar that goes toward a legal modification or a state enforcement fee is a dollar that could have been invested in a small business, a retirement account, or a child's future startup. But the complexity of the economic footprint doesn't end with the current income. We have to look at what happens when the state begins to look at your future potential. How does the court value a business you haven't built yet? Or a pension that won't vest for another 15 years? We are moving into a territory where the law attempts to predict the future, often with devastating financial consequences. In the next part, we are going to explore the high-stakes world of retirement asset division and the Qualified Domestic Relations Order, or QDRO. We will look at how a 40-year career's worth of savings can be sliced in half in a single afternoon, and the specific tax traps that can leave you with a fraction of what you thought you had. We will examine why your 401k is not actually worth its face value in a divorce, and how the hidden fees of liquidation can destroy your retirement dreams. If you think the monthly support payments are a burden, wait until you see what happens to your golden years when the court applies the math of the QDRO. The math of the Qualified Domestic Relations Order, or QDRO, is where the long-term economic footprint of a divorce becomes mathematically permanent. To understand this, we must look at the case of an individual named Michael, a civil engineer who has spent 25 years contributing to a 401k and a defined benefit pension plan. In the marital balance sheet of 2026, Michael's retirement assets are valued at $800,000. In a divorce settlement, these are not just numbers on a screen. They are future survival units. The QDRO is the legal instrument that allows for the tax-free transfer of a portion of these retirement assets to a former spouse. However, the process is far from a simple split. It is a highly technical procedure that involves the plan administrator, the court, and specialized actuarial calculations. Imagine if the court awards Michael's spouse 50% of the marital portion of his retirement. This doesn't mean Michael simply writes a check. A QDRO must be drafted to comply with both state law and the specific rules of the Employee Retirement Income Security Act, or ERISA. If the QDRO is drafted incorrectly, the plan administrator will reject it, leading to thousands of dollars in additional legal fees to correct the document. Step by step, the wealth begins to bleed out through administrative friction. For a character like Michael, the QDRO process alone might cost $3,000 to $5,000 in specialized drafting fees. This is before a single cent is actually moved. Historical trends show that the most significant danger in a QDRO is the valuation of the assets at different points in time. If the divorce is filed in 2024, but the QDRO isn't finalized until 2026, who gets the gains or losses in the market during those 2 years? If the stock market experiences a 20% surge, and the order was written to give the spouse a flat dollar amount rather than a percentage, Michael might be inadvertently keeping a massive windfall. Conversely, if the market crashes and the order was written as a percentage, the spouse might receive far less than they anticipated. This timing risk is a potential outcome that can swing the final net worth of either party by tens of thousands of dollars. Furthermore, we must address the tax trap of the 401k versus the Roth IRA. In a deep dive into the economic footprint, we have to recognize that not all dollars are created equal. If Michael keeps a $400,000 traditional 401k, and his spouse receives $400,000 in home equity, the spouse has won the mathematical battle. Why? Because home equity, up to certain limits, is often accessible tax-free upon sale. Michael's 401k, however, is a deferred tax liability. When he eventually withdraws those funds in retirement, every dollar will be taxed as ordinary income. In a 2026 tax environment, that $400,000 account might only represent $280,000 in actual spending power. This lack of tax parity and asset division is one of the most common ways that the economic footprint of a divorce expands silently over decades. Now, consider the defined benefit pension, a disappearing but still vital part of the American economic landscape for public sector employees and older workers. Slicing a pension is an actuarial nightmare. The court must decide between a shared interest or a separate interest approach. In a separate interest QDRO, the former spouse's portion is actuarially adjusted to their own life expectancy. If Michael's spouse is younger and expected to live longer, their monthly check will be smaller than Michael's, even if the total value is nominally equal. If Michael dies before he retires, and the QDRO did not explicitly include survivor benefits, his former spouse might receive absolutely nothing from the pension they spent 20 years helping to secure. This is the zero-sum game of retirement division, where a single missing sentence in a legal document can result in the total forfeiture of a six-figure asset. The economic footprint also touches on the Social Security system, a crucial pillar for the 2026 retiree. Under United States federal law, if a marriage lasted 10 years or longer, a divorced person is entitled to claim benefits based on their former spouse's earnings record, provided they are currently unmarried. The fascinating part of this economic mechanic is that it does not reduce the primary earner's benefit. It is a rare instance of the system creating value out of a split. However, the timing of when to claim these benefits is a high-stakes calculation. If Michael's former spouse claims early, they receive a permanently reduced monthly amount. If they wait, they maximize the footprint of Michael's career on their own financial stability. This interaction with federal entitlements adds a layer of complexity to the post-divorce recovery that requires years of strategic planning. Case studies of the Gray Divorce, divorce among those 50 and older, reveal a devastating trend in retirement security. When a couple in their late 50s splits their assets, they lose the ability to catch up. They are no longer in the accumulation phase of their lives. They are entering the distribution phase. Taking a $500,000 retirement fund and turning it into two $250,000 funds means that neither individual may have enough to maintain their lifestyle. They both move from a comfortable retirement trajectory to one of financial fragility. They might find themselves forced to work until 75 or move into shared housing, A stark departure from the American dream they were building just a few years prior. Step by step, the liquidation of these accounts also triggers immediate costs. If a spouse needs immediate cash and decides to take a distribution from the 401k they received via QDRO, they can avoid the 10% early withdrawal penalty under a specific IRS exception for QDRO transfers. However, they cannot avoid the ordinary income tax. In 2026, a spouse receiving $100,000 who decides to cash it out to buy a home or pay off debt might see $30,000 go straight to the government. This is a massive loss of compounding power. That $30,000, if left invested for another 15 years at a 7% return, would have grown to over $80,000. This is the hidden cost of the liquidity crisis. You aren't just losing the money today. You are losing the future wealth that money was destined to create. We must also look at the impact on professional certifications and advanced degrees. In some states, a law degree or a medical license obtained during the marriage is considered a marital asset with a quantifiable value. Imagine if Michael's spouse worked 2 jobs to put him through engineering school. The court may determine that the spouse is entitled to a portion of the enhanced earning capacity Michael will enjoy for the rest of his career. Calculating this involves projecting Michael's future earnings, subtracting what he would have earned without the degree, and discounting that total to its present value. This results in a massive lump sum payment or a long-term maintenance obligation that can follow Michael for 20 years. It is an economic footprint on his very brain and labor, a permanent lien on his professional identity. The complexity of these calculations is why the economic footprint of divorce is often managed by a shadow army of professionals: forensic accountants, QDRO specialists, and business valuators. Their fees are the friction of the system. In a high-asset divorce, it is not uncommon for a couple to spend $50,000 just on the experts required to value the assets they are trying to split. This is capital that is permanently removed from the family's legacy. As we continue this masterclass, we have to face an even more difficult reality. The numbers on the spreadsheet are one thing, but how does the economy respond to the shifting dynamics of the individuals involved? What happens when one party tries to hide assets in the digital shadows of cryptocurrency or offshore entities? And how does the 2026 labor market treat a person who has been out of the workforce for a decade and is now forced back in by economic necessity? In the next part, we are going to explore the high-tech world of forensic accounting and the hunt for hidden wealth. We will look at how the economic footprint is often obscured by deliberate financial engineering and the step-by-step process used to uncover it. We will examine the valuation of digital assets, from Bitcoin to private equity stakes, and why your biggest financial threat might be the things you didn't even know your spouse owned. If you think your assets are safe, wait until you see the tools the modern forensic investigator uses to tear down the wall of financial secrecy. The hunt for hidden wealth in 2026 has moved far beyond looking for a second paper bank statement in a shoebox. To understand the modern forensic landscape, imagine a situation involving a character named Jennifer, whose spouse is a high-earning consultant. During their marriage, their lifestyle was consistent with a $300,000 annual income. However, as soon as the divorce papers were served, the reported income mysteriously dropped by 40%. This is the beginning of a financial game of hide-and-seek that utilizes the digital architecture of the modern economy. Forensic accountants today look for what they call the lifestyle analysis. If the reported income cannot sustain the mortgage, the country club dues, and the private school tuitions, then there is a leakage of unreported capital. Step by step, the investigator reconstructs every grocery bill, every gas station stop, and every digital subscription to find the discrepancy between the reported tax return and the actual cash outflow. In the world of 2026, cryptocurrency has become the primary frontier for asset concealment. Imagine if Jennifer's spouse had been quietly diverting 5% of his paycheck into a cold storage hardware wallet for 3 years. Because these transactions are decentralized, they don't appear on a standard bank balance sheet. Forensic experts now use blockchain analytics to trace pings between known exchange accounts and private wallets. They look for small, recurring transfers to platforms like Coinbase or Kraken, and then follow the digital breadcrumbs. If they find a transfer to an unknown wallet address right before the divorce filing, that becomes a focal point of the litigation. Historical trends show that while many believe crypto is anonymous, the public ledger of the blockchain often provides a more permanent and traceable record than cash ever did. The cost to hire a crypto forensic specialist can range from $10,000 to $25,000, which is another massive addition to the economic footprint of the divorce. Yet the potential outcome of finding a hidden $1 million Bitcoin stash makes it a necessary gamble for many. Beyond digital currency, we have the concept of the double ledger in small businesses. In the United States, many divorcing parties own or have interests in S-corp or LLCs. A common tactic is the deferred contract. Imagine Jennifer's spouse has a major client ready to sign a $100,000 deal. To keep that asset off the marital balance sheet, he might ask the client to delay the signing and the payment until after the divorce decree is finalized. Forensic accountants counter this by performing a deep dive into the business's sales pipeline and accounts receivable. They look for anomalies in the timing of revenue. If a business that usually generates $50,000 a month suddenly shows zero revenue during the 6 months of active litigation, a red flag is raised. They will subpoena the business's emails and CRM data to prove that the value was earned during the marriage, regardless of when the check was deposited. Then there is the issue of the shell game involving friends or family members. A person might repay a non-existent $50,000 debt to a sibling or a close friend, with the unspoken agreement that the money will be returned once the divorce is over. To catch this, investigators perform a look-back period of 3 to 5 years, analyzing every large transfer out of joint and individual accounts. They look for lifestyle subsidies, where a spouse's business pays for personal expenses, like a company car that is actually for personal use or a business trip that is actually a vacation. In 2026, the IRS and the family courts have become increasingly synchronized, meaning that if you claim a business expense to lower your tax bill, but that expense was actually a personal benefit, the court will add that value back into your income for child support and alimony calculations. This is known as imputing income, and it can result in a support order that exceeds a person's actual reported take-home pay. The economic footprint also deepens when we talk about private equity and unvested stock options. Many professionals in 2026 receive a significant portion of their compensation in RSUs, restricted stock units. Valuation of these is a mathematical minefield. If the options have invested, do they have a value today? Some courts use the coverture fraction, or the DeLorean formula, to determine what percentage of those future shares belong to the marriage. It is a calculation of the time worked during the marriage divided by the total time required for the shares to vest. If Jennifer's spouse has $1 million in stock vesting next year, and they were married for 4 out of the 5 years of the vesting period, the court might rule that 80% of that future million is marital property. This creates a massive future tax and liquidity problem. How do you pay your spouse their share of $1 million today when the stock can't be sold for another 12 months? Often, the only solution is to take on a high-interest bridge loan, or to trade away other liquid assets like the house or savings, leaving the payer in a state of asset-rich but cash-poor vulnerability. We must also consider the cost of wasteful dissipation. If one spouse spends marital funds on an extramarital affair, gambling, or an intentional shopping spree to spite the other, the court can order that those funds be credited back to the innocent spouse. Imagine if Jennifer finds out her spouse spent $40,000 on luxury gifts for someone else. In the final division, the court might give Jennifer an extra $40,000 from the remaining savings to make her whole. However, the legal fees required to prove the dissipation, subpoenaing credit card records, hiring a private investigator, and documenting the timeline, often cost $20,000 on their own. You are spending 50 cents to chase a dollar, a cycle that defines the inefficiency of the divorce economy. Step by step, the hunt for assets moves into the realm of the intangible, in the creator economy. How do you value a YouTube channel with 2 million subscribers? In 2026, social media accounts are recognized as income-producing businesses. A forensic accountant must look at the goodwill of the brand. Is the value tied to the person or the platform? If the channel generates $50,000 a month in ad revenue and sponsorships, the court sees a multi-million-dollar asset. Valuing this requires a discounted cash flow analysis, where they project the earnings for the next 5 to 10 years and bring that value into today's dollars. This is incredibly risky. What if the creator gets canceled, or the algorithm changes next month? The payer might be forced to buy out their spouse based on a high valuation, only to see the asset's value evaporate shortly after the divorce. Case studies show that creators often face a burnout phase post-divorce because they are essentially working for their former spouse for years to pay off the valuation of their own persona. The administrative footprint of this secrecy and discovery process is a total drain on the national productivity. While these professionals are experts at what they do, Their labor is fundamentally non-productive in an economic sense. They aren't creating new products or services. They are merely shifting existing wealth while taking a significant percentage as a transaction fee. When you multiply this by the hundreds of thousands of divorces that occur in the United States every year, you realize that billions of dollars of American intellectual and financial capital are being diverted into the machinery of forensic investigation. This is money that isn't going into the stock market, isn't funding startups, and isn't paying for the next generation's education. As the hunt for hidden wealth concludes, the focus shifts from finding the money to the long-term reality of living with the result. The courtroom battle eventually ends, but the economic consequences move into a new, more subtle phase. The divorce hangover is a decade-long period of reduced credit access, higher insurance premiums, and the struggle to rebuild a solo retirement. But there is a factor that overshadows even the most complex forensic audit: the impact of the split on the children's economic future. In the next part, we are going into the generational footprint. We will examine the data on how parental divorce correlates with a child's future student loan debt, their likelihood of homeownership, and their own eventual earning potential. We will look at the succession gap that occurs when family wealth is liquidated instead of passed down. If you think the cost of divorce was just between two people, wait until you see the bill that gets passed down to the next generation. We are going to look at the math of the inheritance tax of the living and how it changes the American landscape for the next 30 years. The inheritance tax of the living is not a government levy. It is the structural evaporation of generational wealth that occurs when a family's core assets are liquidated to fund two separate lives. To see this in action, let's look at the story of the Miller family in 2026. The parents, after 22 years of marriage, hold a diversified portfolio consisting of a paid-off primary residence, a small vacation rental in Florida, and a college fund for their two children, Leo and Maya. In a unified household, these assets represent a launchpad. The equity in the home serves as a low-interest credit line for the children's first business ventures, and the concentrated savings ensure they graduate from university debt-free. However, the moment the divorce process begins, this launchpad is dismantled. The vacation rental is sold to pay for the immediate surge in legal fees and the cost of two separate rental deposits. The primary residence is refinanced to buy out the mother's share, saddling the father with a new, high-interest debt that consumes the cash flow previously earmarked for the children's wedding funds or home down payments. For Leo and Maya, the economic footprint of this split is immediate. The bank account that was supposed to cover their senior year of college is suddenly 40% smaller because it was tapped to cover the expert witness fees during the valuation of the father's dental practice. This is the first step in a cascade that historical trends show can delay a child's entry into the middle class by 5 to 7 years. We must look at the data regarding student loan debt as a secondary economic footprint. In a 2026 United States economy where the cost of a 4-year degree at a state institution has reached astronomical levels, the loss of a unified parental contribution is catastrophic. Case studies indicate that children of divorced parents are significantly more likely to take on high-interest private student loans. When the parental unit splits, the FAFSA, the free application for federal student aid, calculations change. In some scenarios, the child might qualify for more aid if the custodial parent has a lower income, but in many professional class families, the total resources available to the child actually decrease. The child becomes a casualty of the liquidity crisis. Instead of entering the workforce with a net zero balance, they start their career with $80,000 in debt. This debt acts as a tax on their future earnings, preventing them from contributing to their own 401k plans or saving for their own children's future. The divorce of the parents in 2026 effectively taxes the wealth of the grandchildren in 2050. Furthermore, let's analyze the housing market impact on the next generation. Imagine if the Miller children were counting on an inheritance or a family-assisted down payment to enter the housing market in a high-cost area like Austin or Seattle. Because the parental wealth was split and consumed by the inefficiencies of two households, that assistance evaporates. Leo and Maya are forced to remain in the rental market longer. In the current economic cycle, where rent prices continue to outpace wage growth, every year they spend renting is a year they aren't building equity. Historical trends suggest that children from divorced households are less likely to own a home by age 30 compared to their peers from stable, unified households. This isn't due to a lack of ambition. It is due to the depletion of the family's capital reserves decades earlier. The economic footprint is a multi-generational lag in asset accumulation. Step by step, We also see the collapse of the family's social and professional network as an economic asset. In the American economy, who you know is often as important as what you know. A unified family often maintains a broad network of professional contacts, country club memberships, and community ties. Divorce often results in a social fracturing. If the parents no longer attend the same industry galas or community events, the children's access to high-level internships or first job referrals can be cut in half. This is the intangible economic footprint, the loss of social capital. If Maya loses the connection to her father's business partner because of a high-conflict split, the potential outcome is a lower starting salary or a longer period of underemployment. We must also address the health and productivity footprint on the children. It is a documented economic reality that high-stress domestic environments correlate with lower academic performance and higher rates of absenteeism in the workforce later in life. If the divorce process is protracted and involves the children in the conflict, the psychological toll can manifest as a productivity tax throughout their 20s. They may require more mental health interventions, which in 2026 are a significant out-of-pocket expense, or they may struggle to maintain the high-performance consistency required in specialized fields like law, medicine, or engineering. The economic footprint of the divorce is thus written into the child's future tax returns as lower lifetime earnings. Now consider the impact on the bank of mom and dad for life's major milestones. In 2026, many young adults rely on their parents for help with a car purchase, a medical emergency, or even the costs associated with starting a family. When the parents are living on separate, smaller budgets, their ability to act as an emergency fund for their adult children is compromised. If Leo loses his job in a tech layoff, a unified set of parents might easily house him and support him for 6 months. Divorced parents, especially those who may have remarried and have new financial obligations, might not have the space or the liquid cash to provide that safety net. This forces the adult child to turn to high-interest personal loans or credit cards, further eroding their own financial stability. The generational footprint also affects the transfer of knowledge. Financial literacy is often passed down through family involvement in managing the household portfolio. When a portfolio is liquidated or simplified due to a split, there are fewer opportunities for the children to learn about complex investments, tax planning, or estate management. They aren't sitting at the table when the parents discuss the family trust because the family trust has been dissolved to settle the litigation. This creates a knowledge gap that leaves the next generation more vulnerable to predatory financial products or poor investment choices. In a deep dive into the economic footprint of Divorce 661, we must conclude that the family is the most efficient economic unit ever devised. It pools risk, centralizes assets, and provides a low-cost internal market for labor and support. When that unit is broken, the efficiency is lost forever. You are not just paying a lawyer in 2026. You are paying a hidden interest rate on every dollar your children will earn for the rest of their lives. We are seeing a structural shift where the wealth that used to move vertically, from parent to child, is now moving horizontally, to the legal, real estate, and financial services industries. But as devastating as the generational impact is, there is a broader macroeconomic footprint that affects the entire United States. When millions of households undergo this transition simultaneously, it changes the way our cities are built, the way our social security system is taxed, and the way our banks manage national debt. The collective cost of these individual tragedies is a multi-billion-dollar drag on the American GDP. In the next part, we are going to look at the divorce economy at scale. We will examine how the surge in single-person households is driving up the cost of urban real estate, and how the legal system has become a permanent, self-sustaining industry that thrives on domestic volatility. We will look at the rise of divorce insurance and other exotic financial products designed to hedge against the collapse of a marriage. If you thought the cost to your family was high, wait until you see the bill the American taxpayer is picking up for the systemic instability caused by the 661 footprint. We are going to expose the hidden subsidies and the silent winners of the American breakup industry. The silent winners of the American breakup industry operate within a complex ecosystem that thrives on the fragmentation of the nuclear household. To understand the divorce economy at scale, we must look at the macro-level shift in housing demand. In 2026, the United States is facing a structural housing shortage, but this shortage is exacerbated by the fact that a single divorce effectively removes one housing unit from the available pool, while creating an immediate demand for a second. When a couple like Mark and Sarah from our earlier example splits, they go from occupying one 3-bedroom home to needing 2 separate residences. This doubling of demand across hundreds of thousands of cases annually puts an immense upward pressure on both the rental and purchase markets. Historical trends show that the rise in single-person households is a primary driver of urban gentrification and rising costs in suburban hubs. When a family home is liquidated and the parties move into two smaller apartments, they are competing with young professionals and retirees for a limited supply of inventory. This competition drives up prices for everyone, meaning the American taxpayer who is not even involved in a divorce is paying a higher rent or mortgage because of the systemic instability of others. The silent winners here are large-scale institutional landlords and real estate investment trusts that benefit from a perpetual churn of desperate, high-need renters who require housing immediately and have little room to negotiate. Beyond real estate, we must analyze the expansion of the legal and administrative state. In 2026, the family court system has evolved into a massive, self-sustaining bureaucracy that requires constant fuel in the form of litigation. Consider a character named Thomas, a civil servant whose divorce has been mired in the system for 3 years. Every motion filed, every hearing scheduled, and every court-appointed mediator assigned represents a transaction in a shadow economy. This industry includes not just lawyers but court reporters, process servers, forensic evaluators, and supervised visitation centers. These services are often mandated by the state but paid for by the individuals. However, the infrastructure required to run these courts, the salaries of judges, the maintenance of government buildings, and the digital record-keeping systems, is subsidized by public tax dollars. We are looking at a system where the public pays to maintain the arena where private wealth is cannibalized. A significant and often ignored part of this footprint is the rise of exotic financial products, such as divorce insurance or specialized litigation funding. In 2026, private equity firms have entered the matrimonial space, offering to fund the legal costs of a lower-earning spouse in exchange for a percentage of the final settlement. This turns a domestic dispute into a tradable financial asset. Imagine if Sarah, lacking the liquid cash for a high-powered attorney, signs an agreement with a litigation funder. The funder provides $100,000 for the best experts and lawyers. In return, they take 20% of the final settlement. This introduces a third-party profit motive into an already volatile situation. The funder has no interest in a quick, amicable settlement. They maximize their ROI when the settlement is as high as possible, which often means prolonging the conflict to squeeze every possible dollar out of the marital estate. Step by step, we also see the impact on the insurance industry. As we discussed earlier, the loss of multi-line discounts is a windfall for insurance carriers. When a unified family policy is split into two individual policies, the total premiums paid to the insurance company almost always increase, even if the coverage remains the same. This is a silent transfer of wealth from the American middle class to the insurance sector. Furthermore, the risk profile of a divorced individual is often calculated differently by actuaries. Data suggests that individuals undergoing major life transitions like divorce may be statistically more prone to accidents or health claims due to stress-related illness. Consequently, the insurance industry adjusts its rates upward, not just for the individuals, but for the entire risk pool. We must also address the health and human services footprint. When a divorce results in the economic collapse of a household, the state often has to step in to provide a safety net. This includes food assistance, subsidized healthcare, and housing vouchers. Case studies from 2026 show that a significant portion of new applicants for public assistance are individuals who were firmly in the middle class just 24 months prior. The transition from a two-income household to a single-parent household is the single most common trigger for entry into the social safety net system. This means that the economic footprint of a private divorce is partially socialized. The cost of providing these services is borne by the general public, making every citizen a silent stakeholder in the stability of American marriages. Then there is the corporate productivity gap. In a deep dive into the United States labor market of 2026, we find that divorce-related stress and administrative requirements cost American businesses billions in lost man-hours. Imagine a large corporation with 10,000 employees. At any given time, a percentage of those employees are navigating the 661 footprint. The time they spend on the phone with lawyers, the days they take off for court appearances, and the general cognitive load of the crisis results in a measurable dip in performance. Human resource departments in 2026 have had to expand their employee assistance programs to include divorce coaching and financial counseling, just to keep their workforce functional. These corporate overhead costs are eventually passed on to consumers in the form of higher prices for goods and services. Another silent winner is the consumer credit industry. As individuals struggle to furnish new homes and cover the initial liquidity gap, they often turn to high-interest revolving credit. The surge in credit card debt following a household split is a reliable revenue stream for banks. In 2026, with interest rates on unsecured debt remaining high, the finance charges alone can consume a significant portion of a divorced person's disposable income for years. Banks effectively become a permanent partner in the post-divorce life of the American consumer, collecting interest on the debt required to simply reset a life. As we look at the macroeconomic scale, we see that the 661 footprint is not just a collection of individual stories, it is a massive reallocation of capital. It moves money from long-term savings and generational wealth into short-term consumption, legal fees, and interest payments. This shift reduces the overall capital available for long-term investment in the American economy. It is a slow-motion erosion of the country's financial foundation. The divorce economy is a parasite on the growth economy, thriving on the friction and inefficiency created when one thing is broken into two. But there is a final, even more complex layer to this footprint. It is the way the economy is forced to adapt to the changing nature of the American family itself. As the traditional household becomes less common, the very products we buy, the way we design our cities, and the way we plan for the national future are being forced to change. In the next part, we are going to look at the market of the individual. We will examine how industries are rebranding themselves to cater to the divorced consumer and the psychological tactics used to sell the fresh start. We will look at the booming industry of post-divorce travel, wellness, and lifestyle rebranding. We will also explore the second-time-around wedding industry, a multi-billion-dollar sector that thrives on the hope of a better second act. If you thought the first divorce was expensive, wait until you see the math of the rebound economy and the financial risks of the second marriage. We are going to look at why the economic footprint of the first split often dictates the failure or success of everything that comes after. The rebound economy of 2026 is a sophisticated market machine designed to capture the liquid capital of individuals seeking a total identity reset. After the grueling process of asset division, there is a documented psychological phenomenon where newly single individuals experience a surge in compensatory spending. To understand this, let's look at the case of a character named Kevin. After finalizing a 2-year legal battle that cost him 40% of his net worth, Kevin feels a desperate need to reclaim a sense of agency. This manifests in what marketers call the Fresh Start package. Kevin upgrades his wardrobe, invests in a high-tier gym membership, and perhaps purchases a vehicle that reflects his new status rather than his former family-oriented utility. While these appear to be individual choices, they represent a collective shift of billions of dollars into the lifestyle and wellness sectors. In 2026, the wellness industry has specifically targeted the divorce demographic with luxury retreats and coaching programs that can cost upwards of $10,000 for a single week. This is money that, in a previous life, might have gone into a child's $529 college savings plan, but is now redirected into the personal branding of the individual. The financial risk becomes exponential when we move from personal spending into the realm of the second marriage. Historical trends in the United States suggest that second marriages have a higher rate of dissolution than first marriages, yet the participants often enter them with more complex financial baggage and less formal protection. Imagine Kevin meets someone who is also recently divorced. They both carry the economic scars of their previous splits: child support obligations, depleted retirement accounts, and perhaps a shared custody schedule that limits their geographic mobility. When they decide to marry in 2026, they are not just merging two people, they are merging two complex financial ecosystems that are already under strain. If they fail to utilize a prenuptial agreement, often out of a desire to prove that this time is different, they are setting the stage for a second economic footprint that could be even more devastating than the first. Because they are older and have less time to recover, a second divorce frequently leads to a total collapse of retirement readiness. Step by step, the second-time-around wedding industry also extracts its pound of flesh. In 2026, the average cost of a second wedding in the United States has risen to nearly $25,000. While smaller than the first, this is capital that is often being pulled from savings that should be dedicated to rebuilding a net worth that was recently halved. The industry thrives on the hope of a better second act, using sophisticated psychological tactics to justify the expense as a necessary investment in a new beginning. We see this in the surge of destination weddings and elaborate vow renewals that serve as a public declaration of financial recovery, even when the underlying balance sheet is still fragile. This is the rebound economy in its most visible form, a celebration funded by the remnants of a previous life's equity. We must also analyze the impact of blended families on the economic footprint. When Kevin remarries, he may find himself in a position where he is financially responsible for his biological children, while also contributing to the household of his new spouse's children. This creates a multi-directional drain on resources. In 2026, the cost of maintaining a blended family household is significantly higher due to the logistical complexity of coordinating multiple schedules, residences, and extracurricular activities across different sets of parents. The administrative footprint of a blended family involves managing multiple insurance policies, navigating different child support jurisdictions, and often paying for higher capacity housing to accommodate a rotating cast of children. This complexity reduces the household's ability to save or invest strategically, as the immediate cash flow demands are constant and unpredictable. Case studies show that the step-parent trap is a real economic phenomenon in the American tax code. While Kevin might provide significant financial support to his new spouse's children, he often cannot claim them as dependents for tax purposes if their biological father is already doing so. This results in a higher effective tax rate for the new household. Furthermore, if Kevin wants to ensure his biological children inherit his remaining assets, he must engage in complex estate planning involving trusts and specialized legal structures. In 2026, the cost of setting up a revocable living trust or a QTIP trust can range from $5,000 to $15,000. Without these protections, the economic footprint of his first marriage and his new marriage will collide upon his death, potentially leading to a protracted legal battle between his first wife's children and his second wife. This is the inheritance war of the 2020s, where the lack of a unified family structure leads to the further enrichment of the legal industry at the expense of the heirs. The rebound economy also extends into the professional world. Many individuals, after a divorce, feel the need to pivot their careers. They might leave a stable corporate job to pursue a passion project or a startup, seeking the autonomy they lacked in their marriage. While this can lead to positive outcomes, the historical trend shows that the success rate for these midlife career pivots is low, especially when they are funded by a depleted capital base. If Kevin uses his remaining $40,000 from a retirement buyout to start a boutique consulting firm in 2026, he is operating without a safety net. If the business fails within the first 24 months, as many do, he has effectively finalized the destruction of his financial foundation. The divorce was the initial earthquake. The failed career pivot is the aftershock that brings down the remaining structures. We also have to look at the social competition factor. In 2026, social media platforms have amplified the need to appear successful and happy post-divorce. This leads to a phenomenon known as lifestyle inflation. For one, to compete with the perceived happiness of their former spouse or their peer group, divorced individuals may overextend themselves on high-status consumption, luxury travel, designer goods, and high-end dining. This spending is often fueled by the temporary liquidity provided by the sale of a family home. They feel rich because they have $100,000 in a checking account for the first time in years, but they fail to realize that this money is not income. It is the liquidated remains of their long-term security. They spend the principal, not the interest, a cardinal sin of personal finance that has a permanent footprint on their future. The economic footprint of the first split dictates the failure or success of the second act, because it sets the starting line. If you enter a new phase of life with significant debt, a tarnished credit score, and a high monthly support obligation, your margin for error is zero. In 2026, the American economy is not forgiving to those without a margin for error. A single medical emergency or a 3-month period of unemployment can trigger a total financial reset. This is why the deep dive into the 661 footprint is so critical. It is about understanding that the decisions made in the courtroom in year 1 will determine the quality of your life in year 20. As we approach the conclusion of this masterclass, we have to synthesize all these parts into a single understanding of the modern American reality. We have looked at the legal fees, the housing collapse, the retirement drain, the generational theft, and the rebound traps. But there is one final question. How does one navigate this landscape without total economic surrender? Is there a way to mitigate the footprint? Or is the system designed to ensure the house always wins? In the final part of this series, we are going to look at the architecture of economic resilience. We will examine the data on those who managed to rebuild their wealth in record time, and the specific strategies they use to bypass the standard pitfalls. We will look at the rise of collaborative law and mediated settlements as a way to starve the legal machine and keep capital within the family. We will also provide a comprehensive checklist for the 2026 economic environment to protect your future, regardless of your relationship status. If you have been following this deep dive, you know the risks. Now it is time to look at the potential outcomes for those who choose a different path. We are going to show you how to draw a line in the sand and stop the footprint from expanding any further. The architecture of economic resilience is not built on luck. It is constructed through the cold, calculated rejection of the adversarial status quo. In the United States of 2026, the individuals who emerge from a household split with their financial dignity intact are those who treat the process as a business liquidation rather than an emotional war. To visualize this, let's look at the case of a character named Elena. Faced with the end of a 12-year marriage, Elena and her spouse make a radical decision. They refuse to hand over the keys to their financial kingdom to a pair of competing law firms. Instead, they opt for collaborative law, a structured process where both parties and their attorneys sign a contract agreeing to settle without going to court. If the process fails and they head to trial, both attorneys must resign. This creates a powerful financial incentive for the professionals to find common ground rather than billable hours through conflict. By choosing this path, Elena preserves nearly 80% of the capital that would have been vaporized in a standard litigation cycle. The first pillar of this resilience is the starvation of the legal machine. Historical trends show that the primary driver of wealth destruction in a divorce is not the division of assets, but the duration of the dispute. Every month a case remains open in the 2026 court system is a month where experts, mediators, and paralegals are drawing from the family's net worth. Case studies of successful recoveries often highlight the use of private mediation as a way to bypass the administrative lag of the state. By paying a private mediator $5,000 to settle the case in a weekend, Elena avoids a 2-year court backlog and the $50,000 in cumulative fees that follow it. This is a strategic preservation of capital. Step by step, the resilient individual identifies every point of friction, from the valuation of a business to the division of personal property, and resolves it through a transparent, data-driven negotiation rather than a high-stakes gamble in front of a judge. The second pillar is the aggressive protection of tax-advantaged growth. As we have explored in this deep dive, the IRS is a silent partner in every divorce. Elena understands that $1 in a Roth IRA is worth significantly more than $1 in a house or a traditional 401k. In her settlement, she negotiates for assets that carry the lowest future tax liability. She uses a specialist to ensure her QDRO is drafted correctly on the first attempt, preventing the double taxation errors that plague many unguided splits. She also looks at the historical trends of capital gains and property taxes, choosing to walk away from a family home that is a liability trap in favor of a diversified brokerage account that can grow unimpeded. This is the move from being asset-rich to being growth-capable. By the time the ink is dry, Elena has a smaller nominal net worth than her former spouse, but she has a significantly higher projected wealth in 10 years because she optimized for tax efficiency. The third pillar involves the immediate recalibration of the solo economy of scale. The resilient individual does not attempt to replicate their married lifestyle on a single income. Instead, they engage in a period of intense financial consolidation. Imagine if Elena moves into a modest, high-efficiency apartment while her former spouse struggles to maintain the oversized family home. She uses the 2026 gig economy and remote work flexibility to pick up specialized consulting contracts, essentially running a surplus in her personal budget from month one. She avoids the rebound economy entirely, bypassing the luxury retreats and identity reset purchases that act as a tax on the emotionally vulnerable. By living on 60% of her income for the first 24 months, she rebuilds her emergency fund and replaces the liquidity loss during the legal phase. This is the math of the fast recovery, reducing the burn rate to maximize the recovery rate. Step by step, we must also look at the strategic use of credit. Elena does not wait for her credit score to dip. She proactively manages her joint liabilities. Before the divorce is even filed, she works with her spouse to close joint credit lines and move recurring bills into individual names. She secures a solo credit card and a small personal line of credit, while her debt-to-income ratio still looks healthy on paper. In 2026, when lenders are increasingly cautious, Having an established individual credit profile is the difference between being able to buy a car or rent an apartment and being forced to use high-interest predatory lenders. Historical trends show that those who disentangle their credit early recover their borrowing power 3 times faster than those who wait for a court order to do it for them. We also have to discuss the human capital hedge. The most resilient individuals in the 2026 economy are those who invest in their own skill sets during the transition. Rather than spending 50 hours a week on the phone with their legal team, Elena spends that time on professional certifications and networking. She treats her earning potential as her most valuable asset, one that cannot be divided by a court. If her marriage was a joint venture that failed, she views herself as a solo startup that needs a new round of funding in the form of updated skills. This proactive approach to career development acts as a shield against the stagnation often seen in high-stress life events. Case studies indicate that people who focus on professional growth during a split often see a 15 to 20% increase in income within 3 years, more than offsetting the alimony or child support they may be paying or receiving. The generational component of resilience is found in financial transparency with the next generation. Elena does not hide the economic reality from her children. She uses it as a teaching moment. She involves her children in the new household budget, explaining the trade-offs required to keep their college funds intact. This prevents the succession gap we discussed in Part 7. By teaching her children about the mechanics of the 661 footprint, she ensures they do not repeat the same mistakes. They learn the value of prenuptial agreements, the importance of individual financial identity, and the danger of over-leveraging a household on a single income. The economic footprint of the divorce is transformed from a tragedy into a masterclass in financial survival for the entire family line. As we conclude this deep dive, we must acknowledge that the economic footprint of divorce in America is a massive systemic force. It is a $100 billion machine that feeds on the complexity of the law and the volatility of the human heart. But for the informed individual, the potential outcomes are not purely dictated by the system. By understanding the math of the house buyout, the tax traps of the 401k, the predatory nature of the rebound economy, and the generational cost of conflict, you can begin to build a different kind of future. This series has been a deep dive into the cold reality of the ledger, but the purpose of looking at the darkness is to find the way back to the light. In 2026, the American dream is no longer a static goal. It is a dynamic process of adaptation. Whether you are navigating a split, contemplating one, or simply looking to protect your household from the systemic risks of the modern era, the data is your greatest ally. You have seen the footprint. You have seen the hidden winners and the silent losers. Now the choice of how you walk the path is yours. This concludes our 10-part masterclass on the economic footprint of divorce in America. If you have found value in this deep dive, your next step is to audit your own financial architecture. Look for the leakages, identify your joint liabilities, and ensure that your wealth is protected by the armor of information. The ledger of your life is still being written. Make sure you are the one holding the pen.